Have you ever really stopped to think about what makes something a crime here in Canada? It's not just as simple as, oh, that was a bad thing to do. Not at all. Think of a serious crime like a recipe. It needs two essential ingredients. And if you're missing even one of them, then legally speaking, there's no crime. Today, we're going to break down that exact recipe.
So, here's what we've got on tap. We're going to start with the big picture, the blueprint of Canadian criminal law. Then we'll dive deep into those two key ingredients, the guilty act and the guilty mind. We're even going to look at a pretty wild twist, how sometimes doing absolutely nothing can be a crime. And to wrap it all up, we'll see how this all works in a messy real-world court case. Let's jump in.
All right, let's get into that blueprint. See, in Canada, our entire criminal law system is built on this one foundational idea. A crime isn't just about what you did. It's just as much about what was going on in your head. So let me ask you this. Just think about it for a second. What is the actual line between something that's just, morally wrong and something that could get you prosecuted by the government? Well, the answer lies in these two core legal ideas. They have these old Latin names, but they are the bedrock of our justice system. And here they are, the two big pieces of the puzzle. You've got the actus reus, that's the guilty act, and then you have the mens rea, the guilty mind. For pretty much every serious crime you can think of, the Crown has to prove both of these, and they have to prove them beyond a reasonable doubt. They have to show you did the thing, and that you had a certain state of mind when you did it. One without the other, it's just not enough.
Now, this is a really important distinction to make. This chart lays it out perfectly, the difference between what we call true crimes and those simpler provincial offenses. So true crimes, things like murder, those are federal, and they absolutely demand both the guilty act and the guilty mind. But think about something like a speeding ticket. That's a provincial thing. For that, all they need to prove is the act itself, the actus reus. Your state of mind is kind of irrelevant. You were either going over the speed limit or you weren't. Simple as that.
Okay, so let's dig into that first ingredient. What exactly is a guilty act? What does the actus reus really mean?
The most important word on this whole slide, maybe in this whole section, is voluntary actus. The actus reus has to be a willed, conscious action. I mean, think about it. If someone grabbed your arm and physically forced you to pull a trigger, you haven't committed the actus reus because your body wasn't acting on your command. It wasn't your voluntary act.
And as you can see, the guilty act isn't always some big, dramatic action. It can actually take a bunch of different forms. It could be failing to do something the law requires you to do. It could be as simple as just possessing something you're not allowed to have. Or it could be about causing a specific forbidden outcome. Any of these can be the physical part of the crime.
Possession is such a fascinating one because it's a physical thing that actually has a mental element baked right into it. To legally possess an item, the law says you need three things. You need to know what it is, you need to consent to having it, and, this is the big one, you need to have control over it. There was this case, R.V. Yoke, where a guy knew there were stolen goods on his property and was okay with it. But he didn't have any actual control over the items, and because of that, the possession charge just fell apart. He was missing that key piece of the recipe. Control.
All right, we've tackled the physical side of things. Let's move on to the second ingredient, which, let's be honest, is often the trickiest part, the mens rea. This is where the law literally tries to get inside a person's head.
So, mens rea, the guilty mind, it's all about what an accused person was thinking. A court will ask questions like, did you intend for this to happen, or did you just know it was a big risk and you decided to do it anyway? That's called a subjective standard, what was actually going on in your mind. But sometimes, the law uses an objective standard. It asks, what would a reasonable person have been thinking in that exact same situation?
So how do courts know which mental state goes with which crime? Well, they don't just wing it. They have to rely on decades, even centuries of previous rulings. We call this precedent. For a crime as serious as murder, for example, the precedent is crystal clear. The prosecution must prove a subjective mens rea. They have to show that the accused person specifically intended to cause death. They can't just say, well, a reasonable person would have known. It has to be more than that.
And this raises a really important point. For something to be a crime, it has to be written down in a law somewhere. Check this out. Back in 1950, in a case called Frey v. Fiducus, a court basically said that, yeah, peeping on your neighbor is definitely morally wrong, but it wasn't a crime. Why not? Because there was no actual law against it. This is so important because it means that judges can't just create new crimes out of thin air, no matter how much they dislike someone's behavior.
Okay, now for a really interesting curveball in the law. Sometimes the actus reus, that guilty act, isn't an action at all.
It's the complete and total failure to act.
And this slide cuts right to the chase. There is a huge difference between a moral duty and a legal one. I mean, if you promise your sick friend you'll drive them to the hospital and then you just don't, you might be a terrible friend, for sure, but you haven't committed a crime. Criminal charges for failing to do something only happen when the law has placed a specific, legally binding duty on you.
And the law is super specific about these duties. For example, Section 215 of the Criminal Code creates a legal duty for parents to provide the necessities of life for their kids. Or let's say you voluntarily agree to take care of a vulnerable person. The law might say that by doing that, you've created a legal duty for yourself. Breaking one of these promises, yeah, that can absolutely land you in criminal court.
So we have the act, we have the mind. Let's see how all this theory gets all tangled up and tested when it smacks into a complicated real-life situation.
Okay, let's walk through a real Canadian case. So picture this. One person attacks another and knocks him out cold, unconscious. Right there, you've got a pretty clear-cut assault. We have the guilty act and the guilty mind. But the story is far from over. Because next, a bouncer shows up and strikes the victim, who is still lying there unconscious. Now, this is what the law calls an intervening act. It's this whole new separate event that could potentially snap the chain of responsibility that started with that first attacker.
And here is the legal nightmare. The victim dies, but the medical evidence comes back inconclusive. The doctors can't say for sure which hit was the one that killed him. So who's on the hook for the death? Is it the first guy? The bouncer? This all boils down to the legal question of causation. Did the first attacker's actions ultimately cause the death?
The Court of Appeals ruling on this was absolutely fascinating. They said that the first assault was a significant contributing factor to the death, and their reasoning was that the first attack put the victim in this helpless, vulnerable state where it was reasonably foreseeable that more harm could come to him. Because of that, the bouncer's actions didn't break that chain of causation. The court actually ordered a new trial, saying both of them could be held legally responsible for the death.
And this all connects to a really famous legal principle called the thin skull rule. It's this idea that an attacker is responsible for all the consequences of their actions, even if those consequences are way worse than they expected because the victim had some kind of unusual vulnerability, like, say, a really thin skull. You have to, as the law says, take your victim as you find them. So let's circle all the way back to that broken promise to a friend. Morally wrong? Probably. But is it a crime? Well, now you have the tools to figure that out. You have to ask yourself, was there a guilty act or a failure to perform a specific legal duty? And was there a guilty mind? The answers to those two questions, well, that's what separates our own personal sense of right and wrong from the incredible power of Canadian criminal law.